My name is Malcolm Niekirk. Welcome to Fretton's 11th and final coffee break briefing of 2023. In case you're wondering about the background behind me, yes, we've had the decorators in, and we've got this mural as part of the facelift of our boardroom. You may recognise it. It's Mudderford Spit, just round the corner from where we are at the moment, with the sandbanks on the spit, the Black House, and beyond it, Hengistbury Head. But enough about that. Let's talk about the coffee break briefings. We'll be continuing them next year. The first one is on Monday, the 8th of January. You might want to put a note in your diary now, because of course that is going to be the first full week back after the new year. So that's Monday, the 8th of January is the first coffee break briefing next year. Now, with all of the briefings we have planned over the next 12 months, you will of course be able to log nearly 6 hours of verifiable CPD. And do remember, if you miss one, they are all recorded, so you will have an opportunity to catch them later if you can't see them live. Now, as always, I'll remind you now to try out the retention of title website tool I showed you earlier this year, and you might want to scribble down a quick note to yourself to have a look at it at the end of this morning's presentation. And my second reminder is that I do pre-pack evaluations. So I'll be very happy to give your buyer an estimate for my fee as an evaluator if you think that you might be selling soon to a connected party shortly after your appointment as administrator. If you would like to ask any questions during the presentation, please ask through the question box. I may pick them up as we go, but it's more likely today that I pick them up at the end. I hope to finish the presentation by 11 o'clock, but I may go on beyond that if I need to deal with questions. Right, so that's the housekeeping out of the way. So let me start the presentation now. So good morning, my name is Malcolm Niekirk. Today I'm going to be talking about centerbinding, which is about liquidators who have, for a short time, very limited powers. And the word centerbinding means different things to different people. To some, it's a description of a particular abuse of the liquidation process. To others, it means a useful insolvency tool, a way of using a liquidation as a very brief interim measure to do a job, almost that of an administration in cases where you need it. And of course, it's also the name of an old case. It's now nearly 60 years old, the original Centerbind case. I will say a bit more about it later today. What I'm going to be talking about, what I'm going to be using the word centerbinding to indicate today, is about doing something useful before the creditors have affirmed your appointment. It is a trick for CVLs and only CVLs, but there are cases when it can be really quite useful. Now, these are the topics I'm going to be talking about today. I'm going to be looking at the normal sequence of events in a CVL appointment, and I'll be moving on from there to talk about what's different in a centerbind, and then looking at where the name came from and talking through the facts of the original centerbind case. Then we get onto the useful stuff, which is when you might want to think about centerbinding a case and the ways that the court can extend your powers in a centerbind. So let's start now with the first of those topics, and we'll look at the normal sequence of events in a CVL appointment. And this diagram shows a timeline where you are perhaps looking at having yourself appointed as liquidator in at least 2 weeks' time from now. And we've got a particular Friday highlighted as the date which will be the decision date for the creditors. And in the course of normal practice, you would also have the winding up resolution passed on that day too. Look back 14 days before that, and that is the earliest date to which the statement of affairs can be drawn up. Statement of affairs cannot be more than 14 days old by the time the company goes into liquidation. If it expires in that time, the directors would have to sign a new statement of affairs. And the critical part of timing for a CVL appointment is usually getting the notices to creditors, and you have to deliver those notices to the creditors at least 3 clear business days before the date on which they decide who they want as the liquidator, the decision date. And in this example here, we've got the absolutely tightest example of that timetable, where the notices are delivered to the creditors on the Monday before the Friday on which the decision date is scheduled, and that then gives Tuesday, Wednesday and Thursday as the 3 clear business days between the creditors receiving that notice and them making their decision the following Friday. So that's the timetable that you're used to working to in most CVLs that you do. But that timetable doesn't have to be followed in exactly that way. There is flexibility to it, and it's using the flexibility that makes a Centerbind different. So let's look at that now and show you what's different in the Centerbind. Here we've got the same Friday in mind, but that is set only for the decision date. That will be the date on which the creditors decide who they want to be as a liquidator. And of course, that can either be by deemed consent, which is where you're telling them who they're going to appoint and they have the right to object, but usually don't, or it could be at a virtual meeting where there will be a formal vote on who is to be the liquidator. So that's the date the creditors decide. I've got here the earliest date for the statement of affairs, which is normally 14 days before the date the company goes into liquidation. The date the company goes into liquidation is, of course, the date when the members resolve for it to go into liquidation, not the date the creditors decide who they want as liquidator. So that 14 days, that can shift according to when the EGM takes place. And here, I've marked the earliest date that the members can resolve for the company to go into liquidation, and that is 14 days before the decision date. So essentially the decision date has to be within 14 days of the winding up resolution passed, but you can still have that gap of up to 2 weeks, and in some cases it can be even longer than that. And of course, if you do that, that date shown on the diagram for the earliest date for the statement of affairs, that will itself go back a further 2 weeks to 2 Fridays before that one. So that's a little visual guide to the way that a Centerbind works. So just talking through that, in a Centerbind, what happens is that the company will go into liquidation, it will pass the resolution to wind up and appoint a liquidator, a second resolution by the members to nominate a liquidator before the decision date under Rule 614, Section 100, however you like to describe it, which is the date on which the creditors appoint or are deemed to have appointed the liquidator. Now that gap in a Centerbind, that gap between the company going into liquidation and the creditors making their decision, that can be up to 14 days, and it can be even longer than that if the decision date is postponed. Now, 2 ways that a decision date can be postponed. One is if it's a virtual meeting, you can adjourn the virtual meeting. Second one is that whether it's deemed consent or a virtual meeting, the creditors have got the right to ask for the decision to be kicked off to a traditional physical meeting of creditors, and that will further postpone the decision. And of course, the physical meeting of creditors itself can be adjourned. So the gap can in some cases be longer than 14 days, but that would be very unusual. And meanwhile, during that period, after the liquidator has been appointed and before the creditors get any say into who the liquidator is actually going to be, the liquidator will take the company's assets into their control. The flip side of all of this is that during that period of time, until the creditors make their decision, the liquidator's powers are very limited. And essentially they are emergency powers only. The general powers, most of the powers a liquidator has got under Schedule 4 can only be exercised with authority from a court in a centerbind. So those powers are essentially on the shelf and you have to ask the court to take them off to use them. There are 3 emergency powers that a liquidator has got in a centerbind. These are the powers they can use without court authority. The first one is the power to take custody or control of the company's assets. I mean, that's almost a duty rather than just a power. Second thing they've got the power to sell fish. Not just fish, but any perishable goods and any other goods that may be losing value. The liquidator does not need authority from the court to sell perishable goods and goods that are depreciating fast. The third emergency power that a liquidator has got is the power to protect the company's assets, and that can be physically protecting the company's assets, putting them under lock and key, or it can be various ways of legal protection for them. So that's what's different in a centerbind, is that you've got this very, very fast appointment of a liquidator, an immediate appointment of a liquidator, while you then get the notices out to creditors and invite them to affirm your appointment or appoint somebody else. And during that time, you are validly appointed as liquidator, but you have only emergency powers unless you go to court to have those powers extended. So let's look at where the name comes from, and let's look at what happened in the original Centerbind case. And of course, as is traditional with the coffee break briefings, this of course is a very old case. I do like going back to some of the old cases that the law is built upon, and just refreshing our memories about all of them. And Centerbind is a great case for doing that. Here's the timetable that applied. It was at the end of September 1966. I didn't mean to look up who was in the charts at that time, but anyway, end of September 1966, Inland Revenue distrained on the company's assets, and the directors realized fairly soon afterwards that this was essentially the end of the company and that there was no way out for them. So they went to see a liquidator, and the notices to creditors calling a meeting of creditors, which was then under section 293 of the Companies Act, before the 86 Act, we used to call them section 48 meetings, sorry, section 98 meetings. But those notices went out at the beginning of November, and that was setting a date for the creditors meeting of the 18th of November. The liquidator due to be appointed realized that this was too slow, that there was the risk that the Inland Revenue would complete their distraint and most of the company's assets would be gone. So on the 8th of November, the shareholders of the company convened an extraordinary general meeting on short notice. They passed 2 resolutions. The first one was an extraordinary resolution to wind up the company and put it into liquidation. The second one was an ordinary resolution appointing a liquidator. The liquidator was Bernard Phillips. That's a name that some of you may recognize. He was very eminent, very well known in his field in his time. And of course, this was 20 years before the 1986 legislation. There was not a regulated insolvency profession in the same way then. Insolvency practitioners did not have to be licensed. And it's true to say that the quality and the ethics of insolvency practitioners was fairly variable. Now, Bernard Phillips was very much reputable, straight down the line sort of liquidator. He no question about his approach to this. The following day, first day of his appointment, he applied to the court for an order staying the distraint, stopping the Inland Revenue from taking away the company's assets. The Inland Revenue challenged his appointment, and they asked the court to decide whether in these circumstances his appointment was valid. That was on the 15th of November. And The law was a little bit different in 1966. Not hugely different, but the important difference for these purposes was that there was a legal obligation on the company when going into liquidation to hold the EGM to wind up the company either on the same day as the creditors meeting or the day before. So there was a very narrow window of opportunities, not like the diagram I showed you where there's a 2-week spread. It was basically either the same day or the day before. And the company had an obligation to send notices to creditors of the meeting of creditors at the same time as they sent notices to the members of the EGM. So that would be essentially 14 days notice going to both creditors and shareholders at the same time. And in the 1948 Companies Act, the only consequence of the breach was that directors or the company could be fined if they failed to comply with this particular timetable. So the court were asked to rule on whether this EGM held on short notice, several days before the meeting of creditors, to put the company into liquidation and appoint a liquidator, was actually valid. The court ruled, yes, it was. The EGM itself was valid, although held on short notice. The members' resolution putting the company into liquidation was therefore valid, and the company was therefore in liquidation, and similarly the resolution appointing the liquidator was also valid. So there was a validly appointed liquidator, and the actions that he had taken, including applying to court for a stay on the distraint, those were all valid. As a result, the liquidator was regarded as having standing to ask the court to restrain the distraint, and the revenue agreed that they would then hold off further enforcement to allow the court to decide whether it should continue. Don't know what happened after that. I suspect that probably the liquidator and the revenue did a deal between themselves, but I don't know for sure. Now, there were a number of consequences to that particular case. The first one was that centre binding became a practical way of protecting the assets of an insolvent company. It meant that if you were at risk of losing the assets by the time you'd given notice to members and creditors of the meeting of creditors, if those 14 days or more were critical, you could appoint a liquidator immediately pending that meeting of creditors and protect the company's assets until that meeting of creditors took place, and the creditors were then able to appoint a liquidator of their choice. Second consequence was that centre binding became an abuse, and there are recorded cases of directors appointing dodgy liquidators who took far too long to call a meeting, and in some cases never actually called a meeting of creditors at all, so liquidated the company for months or even years without actually calling a meeting of creditors to hold them to account. Third consequence is that when we had new legislation 20 years later, we had what we've got now, which is to cut the liquidator's powers to the absolute minimum, to give a liquidator only emergency powers pending the meeting of creditors. And the fourth consequence, this isn't the only reason why we have a regulated and licensed insolvency profession, but it's one of the reasons. So when in the present day might you think about centre binding? When might you possibly look at having yourself appointed in a situation where you've got emergency powers for a short period of time with a meeting of creditors or a deemed consent appointment by creditors following at a later date? First example, fishmongers, fish wholesalers. If you've got something like fish that really needs to be sold now because it's going to perish or because its value is fast depreciating for other reasons, then an immediate appointment as a liquidator will give you the power to sell those assets in those ways. Second example might be a jeweler's. If you need to protect the company's assets, if you've got a jeweler's shop, then by centre binding it, you can make sure that the stock remains in safe custody and remains secure. You may also be able to protect the company's assets. Again, the example of the jeweler's shop. If there is a judgment creditor who is about to enforce, again by center binding, you can put that protection of a liquidation in place immediately, and that will then prevent a judgment creditor from enforcing that judgment, for example, by sending in the sheriff or the bailiffs to uplift the stock. But essentially, the basic center bind gives you only the minimum emergency powers. Sometimes that's enough. Sometimes that can be really useful. And it may be possible to protect the company's assets from the landlord, in that once the company has gone into liquidation, courts will normally stop a landlord from distraining commercial rent arrears recovery, CRA, as it normally is. And for that reason, landlords don't normally bother to try and send enforcement officers in to seize their tenants' goods once the company has gone into liquidation. And also, the courts have got the power to stay legal proceedings once a liquidator is appointed. So that, again, gives you an area of negotiation with the landlord. If you have been appointed as a liquidator, you can tell the landlord that it is going to be possible for you to stay any legal proceedings for forfeiture of the lease. It would be possible for you to, it's doubtful whether that would protect against peaceable re-entry, but a lot of landlords, if faced with a liquidator who's appointed, who's made it very clear that they're going to use their legal remedies to prevent the lease from being terminated quickly, they may well hold off in a situation like that. Next slide suggests that you can center bind to trade the business. Again, think back of that jeweler's shop. Particularly at this time of year, a closing down sale might be the most efficient way of realizing the company's stock. You can't trade a business in a center bind without court authority. It's one of those powers which is in Schedule 4, but you would need sanction in a center bind to use it as a non-emergency power. The other thing you can do in a center bind, if you're looking at extending powers, is you've got the ability to, in an ordinary voluntary liquidation, you can ask the court to confer the additional powers that you might have in a compulsory liquidation. And so those are themselves also additional powers that you could have conferred on yourself in a center bind, is the additional powers that you might get in a compulsory liquidation. Third reason is that once in liquidation, the rights of suppliers to terminate contracts is restricted to some extent by Section 233 and now 233B of the Insolvency Act. I covered those in a coffee break briefing earlier this year, so if you need to know more, you could go back and have a look at what I said there. So let's now look at the court applications that you can make to extend your powers in a center bind. These can be very, very useful, and at the beginning I said that you can think of center binding as being, in the right circumstances, almost like a lightweight short-term administration, and it's by going to court to get these sorts of orders that you can bring a liquidation into that sort of category. So the first one is the power to stop creditors from bringing proceedings or enforcing proceedings, and this is a general direction that you can have added to an order from the court extending your powers. Is just a declaration that creditors should only bring proceedings or enforce proceedings with leave of the court. So that's almost putting up something like an administration moratorium around the company. I've already mentioned the power to trade the business is something that you might well be asking the court to confer on you as a Centerbind liquidator. The next one is an actual stay on existing or threatened legal proceedings. So if you've got creditors who have already started legal proceedings or have got to the point of letters before action, something like that, you can actually ask the court to stay those legal proceedings, stop them from being brought, stop them from being continued. And similarly, if there is enforcement which is imminent or has already started, you may be able to stay that as well. So you may be able to prevent judgment creditors from charging orders or sending in enforcement officers to seize the company's assets. You may be able to protect the leasehold premises that the company has got to some extent from landlords. You may be able to prevent retention of title creditors from taking action to enforce their ownership of goods temporarily, and possibly you may be able to get an order enforcing the rights under section 233, 233B to stop suppliers from terminating key supplies to the company. So those are the additional powers that you can have, which is a useful summary of why it might well be that you would want to Centerbind the company. If anybody's got any questions, this would be an opportunity for you to ask now. If not, I'll just go on to mention a couple of dates for next year. The first one is the next coffee break briefing, which is on the first working Monday of the new year, on the 8th of January. You might want to put a note of that in your diary now. And today I've been talking about a case that is 60 years old. In January, I'll be talking about a case that was decided earlier this year, Avanti Communications, which is a really useful look at the circumstances in which a charge may be regarded as a fixed charge rather than a floating charge. So I'll be talking about that in January. And just a reminder that in spring next year, we will have our third annual insolvency conference, and we will be circulating details of where and when that is to be sometime next year. So anyway, hope you all enjoy the Christmas break and see you back here in the new year. Thank you very much and see you in January.